All right. Good morning, everybody. Welcome back to another lovely discussion of COVID-19. Give everybody a couple minutes to join. I don't know about you, but the old COVID fatigue is starting to creep up on me a little bit. Hopefully everybody else is doing okay, right? Take deep breaths with your mask on, and we'll get there soon enough. Okay, let's go ahead and get started. So I'm your host, Clint Brown. I'm an equity shareholder with the law firm of Roberts Markell, Weinberg, Butler, Haley. I'm board certified in Property Owners Association law and residential real estate. What does board certification mean? It means that I had to take a test with the State Bar of Texas, and they gave me the thumbs up to become specialized in those two areas of the law. And it just means that maybe I know a little bit about what I'm talking about in relation to residential real estate and POA law. So with that said, we are going to be talking collections in the era of COVID-19. Of course, we have kind of discussed collection practices right when COVID was getting started, and we saw moratoriums on foreclosures for certain types of federally backed notes and eviction moratoriums as well. And we had kind of the viewpoint of, look, sit tight, let's stick with our standard collection protocols. And now we're going to be doing a temperature check. Hey, here we are now, coming up on, let's see, it started in March, so we're in November, coming up on a pretty good portion of the year with interacting with COVID and what to do. So what do we do now? Are we going to continue with our collection practices? What are our assessments going to be looking like? Our annual, our quarterly, or our monthly, depending on whether or not you are single family or townhome or condominium. Budget season. Y'all are probably wrapping up your budgets if you haven't already, or you're getting close, or you're smack dab in the middle of it. What do you do for budgeting for next year? And then what's 2021 going to bring for the collection of past due assessments as COVID-19 continues? So first and foremost, this question got asked a few months ago, and we're going to bring it back up. Should POAs reduce or reimburse 2020 assessments? So this year assessments. Before I get into that, I'll give the old POA definition. A property owners association is defined by the Texas Property Code to include single family communities, those bound by Chapter 209 of the Texas Property Code, townhome communities, whether they're bound by Chapter 209 or Chapter 81 or Chapter 82 of the Texas Property Code, and condominiums, which are bound by 81 and 82 or solely 82, depending on the year your declaration was recorded. So it applies to all community associations across the board. So when I use the term POA, all inclusive, discussing everything. So again, question, should we reduce our 2020 assessments? Well, the first thing you really have to keep in mind is that a POA is a non-profit organization bound by Chapter 22 of the Texas Business Organizations Code. That means it is not a money-making entity. It's not a money-making endeavor. Money comes in, the same money that comes in is the same money that goes out. What is the money used for? It's used for paying for vendors. It's used to maintain various aspects of your community. It's used to pay your management company if you've retained a management team. And the management company is going to help manage the assets of the company, maintain the deed restrictions, make sure they're continually enforced, and assist in collection, and assist in vendor retention, vendor negotiation, And in the unlikely event, or maybe likely, depending on what kind of community you are, vendor termination. So all of the services that the nonprofit provides to its members have to be hired out. A very few community associations nowadays that self-run, right, where the board does everything themselves. Why? Because there is a higher liability potential when that is the case. Now, I'm not saying you can't do that effectively. There are plenty of community associations we represent that are effective in that, but most of the time you really do need a management team to help you. In order to do that effectively, you've got to pay, and that's where these assessments come in play. Number one. Number two, contracts typically cannot be suspended or terminated without paying a penalty or the full contract price. Many contracts are not terminable with or without cause. Now, do you have contracts that you've negotiated that way? Absolutely. Try to negotiate that if you can. Sometimes, however, the vendor agreement is what's called a contract of adhesion. You cannot change many terms within the agreement because you do not have enough bargaining power. The smaller the community association is, typically the less bargaining power you've got. So you have this contract. So even if the contractor isn't providing the services that they've been contracted for because you've got the amenity closed, you're still having to pay them. Number one. Number two, let's use a pool, for instance. You're still having to pay for the chemicals and the pool maintenance. You don't want your pool to go green or purple. Why? Because that inevitably affects the plaster around the pool, which in turn causes you to get somebody to come in to do some heavy duty cleaning and or have to replaster the pool, which does what? Costs money. So you've got to maintain your pool. You've got to maintain other amenities as well. So you're going to be paying those bills regardless. And again, contracts with force majeure clauses, that's it's kind of tantamount to an act of God. It's an act that is outside of the association's control and outside of the vendor's control. It many times the force majeure clause is worded so that it does not excuse payment obligations. Again, can we change that moving forward? Yeah, absolutely. You may have some negotiating power. We've done that with a lot of the contracts that we help associations draft in terms of entering into contracts with vendors so that the force majeure kind of takes into account this COVID-19 potential. So again, can we reduce? Well, from a practical standpoint, can we really reduce it? Because we're not saving that much money. Okay, so practically, now let's move over to legal aspects of it. Can you legally reduce the 2020 assessment? Most deed restrictions for the community association do not permit POAs to provide any type of offset or reduction of assessments for any reason. So the budget gets set for 2019 for the 2020 year. The assessments get collected based on the budget. You cannot, many times, the restrictions don't allow you to do a mid-year reduction of assessments, which would allow you to reimburse the assessments to the owners. So if the POA does not have the authority, you cannot take action mid-year. I understand we're already into fourth quarter right now, so that's come and gone. But again, legal perspective, something to think about for 2020. The answer generally is no, you shouldn't have done it. And a lot of associations probably did not. Okay, what about 2021, right? We've got all this extra money for 2020 because we didn't have to pay for all of these services, right? That may not be the case. I've got a ton of community associations that have pools that really got pressure from their owners to open. And look, Governor Abbott, at one point in time, it was 25%. Then it got bumped up to 50. And many community associations got pressure from their owners to open the pool. Well, in order to adequately comply with state requirements, county requirements, and city requirements, if you're within city jurisdiction or ETJ, extraterritorial jurisdiction, you had to comply with some additional requirements. And one of those is kind of cleaning twice a day, ensuring that 6 feet apart is maintained, groupings no larger than 10. And the only real way to effectively do that is to what? Is to hire people to monitor the pool, to monitor the social distancing and the mask face, wearing the mask while you're, interacting or walking to or from your pool chair area. What does that do? It costs money, right? It's not free. So most of my associations met or exceeded their budget. So they don't have additional money lying around. But look, let's assume you've got additional money lying around. Well, for the 2021 assessment year, during your budget consideration, you may be able to lower that assessment. Again, it's not going to be the case for everybody because many associations, if they had those amenities they were opening, had additional costs that they did not anticipate. Many of the associations I've dealt with have actually had to increase their 2021 assessment to take into factor the fact that they're going to have a lot of additional COVID expenses. So what are these additional COVID expenses? First and foremost, it's important to remember that it may be difficult to really estimate the costs for 2021. What I'm recommending, basically try to get estimates from your vendors that are going to cause those added expenses. And again, cleaning your common areas, your clubhouse, the additional pool costs for multiple cleanings at the pool area and the bathrooms, and multiple pool costs for hiring your vendors, right? Having a lifeguard or a pool monitor on duty to ensure that COVID-19 precautions are met. I'm telling a lot of my communities to kind of plan maybe for the fact that COVID-19 may still be around and we're going to have these limits in place when the pool season opens in May. So let's assume this vaccine they're talking about that has a 90% efficacy rating, let's assume it starts being dispersed. I just don't think it's going to be readily available come May of next year. Now, again, I'm not an expert in that, right? I know the law. I don't know how to disperse vaccines, but a lot of the news sources and news stories I've read have talked about how difficult it is to get that vaccine out and to get it produced nationwide and of course worldwide as well. The other thing you can do is to look at your second quarter expenses for 2020, right? So if you were one of those communities that had added COVID-19 expenses, you could probably use that quarter and extrapolate it across the year to come up with a decent number for what you think your 2021 budget should be. And that'll give you an idea as to whether or not you're going to be able to save money and maybe reduce assessments or keep your assessments the same, or you may have to have a little bit of an increase. So, you know what? Talk is cheap, right? Let's talk about an example. Let's go through an example. I've had to work this out with a few of my communities during budget season, one as recent as 2 weeks ago. So we've got a community association. It could be a condo or single family. And we've got, I'm sorry, my phone is ringing. Shouldn't be. And we have got we've got a pool, and they want to open their pool up. Clint, we are planning on opening up our pool next year. What should we do? Well, we've got some options. Option number one, first and foremost, keep in mind that pools are not open 7 days a week usually. There's usually 1 day out of the week that it's closed for pool maintenance, chemicals, all that good stuff, because you don't want people swimming in the pool when you shock your pool with chlorine or something along those lines to get it back in line with pH and all that other good stuff. So option number one, this is the most expensive option. Pool is open 6 days a week with lifeguards that double as intake. So all 6 days, the pool is open. All 6 days, you've got your lifeguard from X to X, and they are monitoring for COVID-19. That's option number one. Option number two, pool is open 6 days a week with lifeguards on Saturday and Sunday, and then the pool monitor on the other 4 days. So you're assuming that Saturday and Sunday are the highest pool usage days, so you have lifeguards on those days, and then the other days you have your monitor checking people in and making sure COVID-19 precautions are being followed. Option number three, pool is open 6 days a week with only pool monitors, or the last option, pool is open 6 days a week with lifeguards and or pool monitors. Now there is a final option, and that is use a SAYOR option, swim at your own risk, regardless of the COVID-19 precautions in place. Our law firm generally recommends against that option because failing to comply with the COVID-19 safety precautions and social distancing precautions can make you liable for a decent amount of money. It also makes the individual offender liable as well. And because you are either the owner or operator of the pool, so you're owner of the pool if you're single family, you are basically the operator of the pool if you are a condominium. We're a little wary for that liability potential. Additionally, we're a little worried about liability potential because if there is a lawsuit related to a COVID-19 incident, there will be no insurance coverage. So the cost of defense is going to be coming out of the association's pocket, which again makes us nervous. Okay, so pool cleaning days assumed, as I mentioned, so 6 days, day 7 is pool cleaning, and you need at least a pool monitor present. You estimate the added cost of janitorial services as well. So not only lifeguards, but you've also got to think about the janitors doing their cleaning duty. I know some lifeguard companies also offer cleaning of bathrooms, and as long as they're properly educated on how to do it, then maybe you can incorporate it that way. You get your pricing for all the different scenarios, and you just choose an option. You either adjust your funding for the next year for 2021 to cover 100%, or maybe you decide to kind of roll the dice, right? Flip a coin. We don't want to do 100% because that would significantly increase our assessment rate. We are going to do a 50% with the understanding that, fingers crossed, we don't have the heavy restrictions next pool season. Now, the only problem with that is you are running a risk, right? Because if those restrictions are in place and you want to open your pool 6 days a week, let's assume you wanted to pick option one, the most expensive option. Well, you may have to go to option 2 or option 3, the cheaper option. You may only be able to open your pool up 2 days a week or 3 days a week so that you can have the budget meet the actual expenses a little bit more closely. So again, I've got a lot of different boards doing it a lot of different ways, and it's okay to not cover 100%. You just have to understand that you're not going to be able to get the service that you wanted because of those added costs. All right, so that's kind of the 2021 assessment idea. Again, if you've got money left over, if you're confident you're going to be well below budget because you're not going to be doing X, Y, and Z, then yeah, maybe you can keep your assessment level the same or decrease. But again, a lot of the community associations I'm dealing with are having to increase their assessment. CPI increases every year as well, so the Consumer Price Index. So most of the time you've got to increase just to comply with CPI increases. Okay, next question. Should you continue your collection process, through the COVID-19 pandemic? Short answer is yes, you should. You should not stop your collection activity. Don't pump the brakes. Continue with your collections. Why? Well, again, a POA is a nonprofit corporation. It depends on the money coming in to be able to pay their contractors money going out. If the money's not coming in, the money's not going out. You start running into deferred maintenance issues if you're a condominium. or if you're maintaining common areas as a single family community. You start having to roll back your deed restriction enforcement protocols so that the area, your community you're living in, is not going to be maintained as well. The lots aren't going to be maintained as well. Why? Because you're not sending those letters out telling people to keep their yards looking nice, to do X, Y, and Z. Don't paint your house purple, all those things. What happens with that? Well, it can affect the appearance and the aesthetics of the community, which in turn can affect buyers' desire to live in the community, which of course has an effect on the fair market value of your property. You're not able to pay your landscapers to maintain the common areas or common elements quite as well. So again, it's important to have the money coming in. And again, I get it. If you want to tighten it up a little bit, maybe you're fully funded on your reserves and you want to be able to reduce it to be more, considerate of your owners that are affected significantly by COVID-19 due to, economic downturn. Maybe they lost their job or they're not making as much money. Then you may be able to do that based on your budget, but it really is association to association. So it's all about reasonable, right? Being reasonable, and POAs should be reasonable with their community members. Why? Because of course, as we've seen with the stock market, economic uncertainty continues, not even related to COVID-19, right? The recent presidential election and the results and all the fighting that's occurred has really affected the stock market. Now, it did a pretty significant rebound this past Monday, but you know how the market goes. So again, economic uncertainty is going to continue, number one. Number two, while you're thinking about being reasonable and working with your owners on the collection process, what is happening as we speak and into next year? The 2021 Texas legislative session is going to be in full swing. It just started in November, and we're really going to see it gear up next year. We don't know how it's going to affect community associations. 2019 legislative session was fairly quiet, right? We didn't have a lot of law changes, but that doesn't mean 2021 is going to be following the same route. We could see a lot of changes. We could see the legislators focusing more on COVID-19 and the economy and things like that. So we don't know what's going to happen. So what I always recommend community associations to be is reasonable. Always be reasonable, but with our legislative session right around the corner, it's important to really think of that, because you do not want legislators' constituents, i.e. the owners in your communities, to write some nasty gram about what the board did, the evil board of directors did to this community owner, because it really doesn't take much for a legislator to take action and file that bill that is really not representative of how most community associations run. So again, keep that reasonableness in the back of your head. An example, House Bill 67 was just filed, restricting an association's right to restrict pool enclosures. Now again, pool enclosures are great. They are required, and they should be utilized, but an association should have the right to at least regulate them to a certain extent. So it's already happening. We've already got a House bill affecting community associations. So keep that in mind when you're working with your owners on COVID-19 related issues, whether it be deed restriction enforcement or collections. So 2021, even if you don't reduce or even increase the 2021 assessment, you can still consider taking the following actions to work with your owners, right? So let's assume you're in a community association where you've kept it the same or you've had to increase it a little bit. What if you do a delay late fee, right? Maybe your late fee is normally, I'm going to assume your annual, let's assume your late fee is normally assessed in February. The board could consider doing a delayed late fee and having it, be incurred at the end of February rather than at the end of January, to give them a little bit more time to kind of catch up and pay that annual assessment if it becomes due. Again, communicate with your owners on that too. Hey, We understand a lot of people have been affected. We're going to do a delay late fee. And you can do it across the board. You can also consider it on a case-by-case basis. If somebody's been affected by COVID-19, it is okay to consider what are called hardship exceptions. Maybe you want to do a delayed interest accrual, or maybe you add one more courtesy letter notice right before you start tagging on the fees and charges and other bills. All things the association can consider either on an association-wide basis or on the basis of hardship exception requests. Payment plans, case-by-case basis. So the POA should, again, consider hardship, reasonable hardship exceptions for residents who are unable to make their payments as a result of financial or other hardships relating to COVID-19. What does that mean? Here are some hardship exceptions that we've encouraged community associations to consider. Our law firm considers them as well. Limited abatement of late fees and interest, as we just discovered. Limited abatement of assessment payments, so kind of a delay start. Extend your payment plans. Do some sort of a deferred payment plan where the payment plan starts in month 3 rather than month 1. Consider what's called a graduated repayment plan, where maybe the first 6 months, the payment is $100 a month. And then in month 7, it increases to $300 a month. And then in month 12, it increases to $500 a month, whatever the case may be, but some sort of a graduated repayment plan to allow your owners to get back on track. But in terms of the collection process generally, association should keep going with their procedures. Most community associations, at least that we represent, your delinquency rate should be south of at least 15%. Newer communities, you should be less than 5. A little older, less than 10. You don't want your delinquency rates to get higher than that, especially just for loan purposes. You can't even get a lender to give you a loan, enter into a transaction with you if your delinquency rates are too high. So how do you keep those delinquency rates low? Work with your management company so that they've got a very set out process to follow in terms of courtesy letters and then their final demand letter, and then have the account turned over to your counsel once those steps have been followed. And then your counsel, he or she, will follow a certain collection protocol as well. It's all about being consistent and following that protocol. Keep in mind that in order to protect your lien rights, collection is what? 4 years. So if I was to file a lawsuit today on an annual assessment association, I could collect 2020, 2019, 2018, and 2017. I can't collect 2016, 2015, 2014, right? Because it's outside the 4-year statute of limitations. Now, there are ways to get around that in terms of working with owners on payment plans. Additionally, bankruptcies, when a bankruptcy gets filed, it freezes that statute of limitations so you can collect a little bit more. But the general rule of thumb, 4 years is what you have to file a lawsuit. Also, filing a notice of assessment lien does absolutely nothing to freeze that statute of limitations. It is 4 years, whichever way you look at it, and filing that notice of lien in the real property records does bupkis for you. Doesn't help. So keep that in mind. Keep your delinquency rates low. And that's going to help the association in the long run maintain their reserves, avoid deferred maintenance, and then give the association the flexibility to work with the owners on those soft costs, right? The interest, the late fees, other fines, all that good stuff, so you can work with people who need that hardship exception. So moving into 2021, it's important to think about basically your operations of your community association to proceed as close to normal as possible. And I get it. We're in a new normal now. There's not going to be as many folks using your common area, your clubhouse if you have one. And we're going to have to live in this new world where we're going to see more and more people wearing face masks out in public. It's going to be commonplace. And there's going to be less handshakes and hugs and just more greetings, waving of the hand. The amount of assessments should be dictated by the annual budget for the POA. It should not be dictated by owners being angry and demanding the assessments remain the same or be lowered. It should be dictated based on your budget. Work with your management company. They know what they're doing on preparing budgets. They're going to give you good numbers that they recommend. And if you have to do an assessment increase, just make sure you explain, very clearly to your owners why you're having to do it. And remember, if you increase your assessments for approving your budget, it's got to be done, if you're single family bound by Chapter 209, it's got to be done at an open board meeting for which proper notice was given. So keep in mind, you've got to notice that and you've got to approve it during the open session portion of your board meeting. If you're a condominium, that is not technically required, but I recommend you do it anyways. Let's follow corporate formalities. Let's try to be transparent in what we do. Now, collection of assessments, again, try to proceed normal. It's crucial that POA community managers and board members be reasonable in their collection efforts. Consider those hardship exceptions when you need to, so that you can help your community move forward in the right direction. And then finally, just continue to review your collection matters on a case-by-case basis. Make sure, and you may already have this procedure in place, but if you don't, get it in place. Make sure your management company's got a very clear set of guidelines for their courtesy letters all the way through their final 209 letter if you're a single family, or just final demand letter if you're a condominium. After that happens, if the years are right, get it referred over to an attorney. He or she is going to then take action and make sure the 4-year statute of limitations isn't missed, so that you start losing assessments year after year. That's a big problem when you've got that delinquency rate creeping up north of 20 or even 15%. And hey, guys, we did good. We got this one done early today. It was going to be an early presentation, but that leaves room for some questions. Kyle, we had some questions submitted to us earlier. So I'm going to go through those here briefly. While I'm doing that, if anybody has any questions, feel free to type them in now, and I'm happy to answer them. So, first question, have parameters involving payment plans changed at all? What is a good rule of thumb regarding payment plan parameters? So the COVID-19 parameters, yes, they did cause change. Are they still in place? Yes, I'm still recommending you be reasonable and work with owners who need a hardship exception. What is the general rule of thumb? If you're dealing with a pre-litigation matter, I like to think, 6 months is a good rule of thumb. And then if they need longer, 12 months, maybe a little bit longer, I think you consider that on a case-by-case basis based on the hardship. For litigation matters, when a lawsuit gets filed, you tend to be dealing with higher dollar figure. Why? Because when an attorney files a lawsuit, it gets expensive in terms of attorney's fees. There's hearings that have to be attended, motions, lawsuits that have to be drafted, so the attorney's fees increase. So in that type of scenario, I like to see payment plans maybe 12 months up to 18 months. And again, hardship exceptions can be considered. It's okay. And then post-judgment, again, it kind of tracks litigation payment plans as well. So the payment plan after you've gotten the judgment. Another question, how or what is an effective way to collect assessments in arrears from board members. Ooh, we've got a board member past due in the payment of assessments. What do? We follow our standard collection protocol. It's got to be followed, right? If it's one board member and it's a board of 3, hopefully the other 2 appreciate that. Now look, if those other 2 want to discuss it with this guy and exec saying, hey, Bob, sorry if there are any Bobs out there. Hey, Bob, look, you're past due on assessments. We have to be consistent in enforcing our collection policy. That means the association is going to be taking action on this. If you need a payment plan, ask us now. Look, we're going to treat you just like we treat everybody else in the community. We're going to be fair. Keep in mind, you have to be consistent. Now, question number 2, what happens if there are 2 board members delinquent on a 3-member board? It's going to be up to that one board member and the manager to have a discussion with those 2 and say, look, it's not okay. We have to be consistent. We have to proceed with collection activity. What happens if they say, well, manager, I appreciate that, but we're voting not to proceed against us? That's a big conflict right there. Get your attorney involved. He or she is going to send you or send those 2 board members and CC the manager and the other board member and really warn of those liability issues and liability increases when you're not consistent in your enforcement. And if all else fails, well, maybe the manager and or attorney may have to consider withdrawing as the management company, because that is a big deal when board members aren't paying their assessments and we're not proceeding against that board member, because those assessments can increase pretty significantly. When do you anticipate the courts will allow attorneys to file matters in court that pertain to collections and non-payment? So the courts haven't stopped. We're still filing lawsuits for collection matters. All that's proceeding. I will say it depends on the county for motions. A lot of times a judge will hear the motion and grant our motion for judgment. Other times they're going to give a little bit of a delay, allow the owners an opportunity to try to get on their feet. It depends on the county in which you're located, number one, and then it depends on the judge that you get. But lawsuits are still progressing. Everything is happening and moving forward appropriately. Another good question here. Are foreclosures still prohibited due to COVID? What is the owner's incentive to pay large balances when foreclosure cannot be done? So again, unfortunately, this really depends on the county. We've got plenty of counties in Texas where foreclosures are proceeding. We've got other counties where the county judge is actually just closing the courthouse, or the mayor maybe closing the courthouse the day before the foreclosure posting, and is really causing a delay. So again, keep proceeding, keep getting your judgments. Judgments are good in perpetuity as long as you take certain actions. They're good for an initial 10 years, and then you can renew them for 10-year successive periods as long as you do certain things. So continue to get your judgments. Try to work with the owners to get them to pay. And, you know, fingers crossed, foreclosures will start up again. Our law firm, I would say less than 1% of the time we ever make it to the foreclosure doorsteps. The other 99 point some odd percent of the time we're resolving the matters, or they're filing bankruptcy, or they're getting foreclosed on by the mortgage company. Another question. What are your thoughts on communities providing a credit for non-usage of the amenities? So an example, the park was closed, didn't have to pay for lifeguards. So again, good question. And I think it goes back to what kind of authority do you have to provide a credit to an owner? You likely have no authority. Maybe you do. Maybe your governing document allows for it, but most of the documents I see, the answer is no, you cannot do a credit. So what do? You reduce the 2021 annual assessment. So even though they don't get to enjoy the benefit this year in 2020, they'll get to see a reduced assessment in 2021. And you send out a little e-blast to your community saying, hey, because we didn't have to pay for X, Y, and Z, there was a savings, and we're putting that towards 2021, or maybe we're investing it into reserve. But regardless, we're able to reduce the 2021 budget because we are not anticipating doing X, Y, and Z. But remember, be careful what you wish for. So what happens when pool season rolls around and there are no restrictions? That could happen. If that is the case and you open your pool, oops, I don't have any money in my budget to pay for X, Y, and Z for the pool. So now you're stuck being underfunded. So it's very tricky, and it's difficult for an association to adequately estimate. My recommendation is to err on the side of caution. Another question: what about commercial condominium associations? So really good question for this. For commercial condos, you typically have maintenance obligations just like any other condominium community in the state of Texas. So your budget is probably not going to change at all, right? I will say for commercial condos, maybe you're seeing less business if you are a community that allows for customers to come into the condominium community. So you're seeing less patrons. Maybe you're seeing tenants that are just unable to pay and are being basically there's a breach of the lease. So again, if you are seeing that, then you need to anticipate there being some financial issues with the owners of the units that you're managing within that condominium regime. But overall, you more than likely should not be reducing your assessment. It should be staying the same or increasing. Any other questions? All right. Well, looks like everybody has a get out of jail free card for today. Y'all got out about 15 minutes early, which is good. Hey, the holidays are coming up. Next week, we are having a discussion on racial inequalities, BLM movement, all that good stuff. We've got our shareholder, Leah Burton, and one of our associate attorneys, Noel Hicks, who are going to be speaking jointly on this topic. It's a really hot topic right now. So hopefully y'all can attend next week. But if you can't and you don't get to see me again, I hope everybody has a wonderful holiday and a happy Thanksgiving. With that, y'all enjoy the rest of your day, enjoy the week, and enjoy your weekend. Try to push through that COVID-19 fatigue, and I'll see y'all soon. Bye-bye.